A business owner walks into court expecting a $15,000 default judgment and walks out learning she can't even ask for that much. This is what happens when investment contracts meet courtroom procedure in DeKalb County, Georgia. The case involves True Colors Entertainment, an LLC that took investment money and never paid it back. But getting that money back requires jumping through legal hoops the plaintiff never knew existed.
Okay, so I True Colors Entertainment, we went into an investment agreement. Um, there is a contractual document that I submitted as well. There's some interest requesting as a default judgment, and then there's also court costs. The owner of the LLC was served personally, in which that was submitted to the court. You asked me to change the document
No, I
referring.
didn't know. I didn't ask you. I'm just tell you what your
Oh, yeah.
issues. Yes.
Okay. I had to correct the document. I had to correct the document, submitted that, and I'm requesting a default judgment.
All right. So the process server was Reddick Legal Services LLC.
Right.
Okay. So what I don't, and this, let me see. I'm gonna look through your documents because we're gonna
That
stating.
was corrected. That was sent in.
Okay. All right. Okay. Let me get to it there.
Oh, yeah.
Okay, do have you submitted the True Colors Entertainment affidavit, default affidavit, but I still don't see the appointment order from the process server, Mr. Reddick.
Oh, yeah. He personally filed that directly in court, in the DeKalb County Court.
No, he didn't do that. All he filed was his affidavit saying he served him. You have to file if you were listening to me, there was cases where the person that was the um that served that we also required them to have a process server affidavit showing that they were appointed by it's appointment order that they were appointed by the court to actually effectuate service. That's the only way we know that this is going to be good service. You see what I'm saying?
Okay, so I went through the court. They couldn't find the individual.
Okay, now that's not
Okay.
has
So
nothing to
I'm
do.
sorry, just give me 1 second, okay? So
Okay,
I'm understanding what we're talking about. So when I went through the court to do that, that was unsuccessful. And then I hired somebody to do that, which was successful, but they're lacking another affidavit to show what?
they're lacking an appointment order to show that they were appointed by the Superior Court of DeKalb County to do the service.
So is that missing on my part? Because I didn't receive, when I talked to the court, they said, well, if you're failing through us, then you can hire somebody to do so. So
Right.
once I hired that individual, was I supposed to say, hey, court, I need somebody to what?
No, no, he or she was supposed to know exactly if that's who you use. They're supposed to know they are supposed to file an appointment order showing that they were actually appointed by the Superior Court of DeKalb County to do service. That's what. So when you heard me talk to these lawyers previously, there was process services where we did not have the appointment order in there, and as a result, that I don't know if that person is qualified to actual to the serve process in the county. So that's why they have an appointment order from the clerk, excuse me, from the Superior Court judge that's signed that says, hey, this individual has the ability to do private process server here in DeKalb County.
Okay, so an appointment order was supposed to be provided, right? Okay.
Yes,
Can
it's
I,
supposed to
can
be
I have a moment?
it's supposed to be provided along with the affidavit of service. Yes, ma'am.
Okay, can I have a moment to contact the process server to see if that was supplied, and if not, figure out
It
where?
wasn't supplied. I'm looking at it.
Okay, maybe he got it and didn't put it with it.
Okay.
I don't know. I'm thinking on the positive side. I know you're doing your
Oh
job,
yeah. Well,
but
I'm just telling you what's
contacting to
here.
find out what I can, what I need to know as far as that goes. And
Yeah.
then can I just have a moment to do that and then come back in
Yeah.
before you
Hmm.
enter
Hmm.
hold?
Yeah. I'll
Okay,
give you about 10 minutes, okay?
perfect. Thank
You'll
you.
end the phone. All right.
Here's what just happened. The plaintiff did everything right, found the defendant, hired a process server, got proof of service, but missed one invisible step. In Georgia, private process servers need a court appointment order proving they're authorized to serve papers in that county. Without it, the service might be invalid, and the whole case collapses. It's like having a driver's license but forgetting your registration, technically legal to drive, but not provable when it matters.
All right, Miss Barbie.
Yeah, I'm still in there.
Thank you.
Yes.
Okay, so I just talked to the process server and he just said that he just sent it to me. He apologized for that matter, but now what will be the next steps? I seen that there was an email, Walker at DeKalb County GA.gov. Is that something that I can just email?
Yep, you can email it to him. But let me just say this to you. You asked him for $15,000. Okay, that's the jurisdiction amount of it. But you also want $89 plus court costs. That exceeds the jurisdiction amount.
Okay, so what should I do?
I can't tell you something that exceeds the jurisdiction amount.
Okay, I will 1,000 at the if that's the end of it or that's the most that I can actually request.
No, I can't see. I can't.
I'm telling you that okay. If I can't include the court costs, and I am fine with what it is.
But the problem is if they appeal it, then you have another issue.
If who appeals it?
The true people.
He hasn't been to a court date since I've gotten this submitted. I don't know if this even bothers him. I'm sure that would be a
right. So let's go back over your situation. So you're asking for, and this is another thing. I remember I told you that my issue was that the amount violated what they call the usury laws. I had that conversation
into
with
detail
you
about that because I think I actually mentioned to you that there was interest included that could exceed the amount that I am actually asking for. Because there was the amount it actually concluded at, I believe, 11,000. That within a specific time frame, if it had not been paid, then it would accrue interest.
Yeah, accruing interest and asking for the 15,000 is two different things. $11,000 on an accrued interest does not come to 15,000 in a year.
It comes.
You see what I'm saying?
It's been more than a year, so it comes to more than that. It would be way more than what I'm asking for.
No, that's not what. That's not. No. You're going to get what the rate of interest is that's set by the state it's what they call pre-suit interest. That is not that high. It's not that high.
Okay,
That's I'm going to award you the level you had given them.
Okay.
I
got a question.
Yes.
Okay, so you said that within the contractual agreement versus the state of Georgia, it would be a totally different way of interest.
No, I said because what happens is it tells you in it says application of payments, acceleration of debt, remaining unpaid balance, and any accrued interest shall become due immediately at the option of the lender. Okay. Now, the ideally is what is the rate of interest that was in here? There's not one, other than the fact of 50% return on investment. There's no rate of interest in your agreement.
Okay.
You see what I'm saying? There's no rate or interest on an agreement. So therefore, I can't award you something has not been set out. So a lot of times the contract will say, well, the rate of interest is prime plus 5 or what have you. It doesn't say that. You see what I'm saying?
I got you.
Okay. So what I can do is I can award you the $11,000 plus what they call post-judgment interest. Okay. And plus your court costs.
That sounds good to me. Thank you.
But before I do that, I got to get that piece of paperwork from
County GA.
I have
No attachment, you said?
Clerk Walker, I'm gonna see, is it already in there? Okay, here it goes. All right. You're
Thank you. One more question. Is this something that'll be mailed to me?
Madam Clerk,
To Madam
I'm assuming, mail to, it will be mailed to you.
It'll be mailed, whichever one.
I'm sorry,
It'll be mailed. Thank you, thank you.
and thank you for your help indirectly.
All right.
The judge awarded $11,000 plus post-judgment interest and court costs, not the $15,000 requested. The plaintiff's 50% return on investment contract language couldn't override Georgia's usury and interest rate laws. The appointment order from the process server arrived during the 10-minute recess, saving the default judgment from procedural failure. The written judgment will be mailed to the plaintiff. Your contract can't invent its own interest rates. State law caps what you can collect, no matter what both parties signed. And in civil court, procedural perfection beats moral certainty every time. Subscribe for more real courtroom moments that teach you how the system actually works.